the policy.
Yes, I have, I suppose, one final observation in this, which is perhaps implicit, which is, of course, on the legitimate expectation argument, in terms of the letter, ambiguity is in the Secretary of State's favour. If there's ambiguity on the letter, the appeal must fail. Legitimate expectation. I want to go then to the policy for two purposes. One, because I submit it supports our argument on legitimate expectation. One on its face, if you were to assume that you had received to think from the letter that you had received an exceptional assurance, you go back and it's doesn't look, you're not getting what the appellant says he's getting in terms of the effect on his application. And two, because it would be extraordinary if someone receiving this kind of short-term assurance that didn't fall into the exceptional assurance policy was getting something better than someone who's subject to an exceptional assurance. So those are the two limbs in which it supports my argument on legitimate expectation. It is also an answer to the pure policy point, which Mr. Malik says his client is entitled to have overstaying, or entitled not to be refused on the basis of overstaying by operation of policy. That's what he said. So, if we can have a look at the policy which is in the supplementary bundle, starting at 85, I should say at this point we have identified and obtained the correct. Well, in fact, it's my client, and I don't know why I hadn't done it beforehand, but they have done it very swiftly. It's been emailed around. It may have even been emailed to your clerks. I'm not sure.
Yet, but I'm sure it will. That's fine.
But nothing. There are no changes.
No changes to the date.
Precisely. So looking at the policy, starts at 85, moving down to.
Sorry, just one point on the
yes.
letter. Perhaps this fits in better at the policy. At some point, you're going to deal with the fact that Mr. Shirley describes what you're calling the short-term assurance as an exceptional assurance.
Yes. Yes. Yeah. Yes.
Yeah, we're going to policy. Yeah.
So 86 is where we start for the core elements of the policy. And the paragraph beginning, if you intend to leave the UK, is the first point to note. And as your Lordship has already identified, it seems to be refer to having a visa, leave or exceptional assurance in the present tense.
Where does it do that?
If you intend to leave the UK
Precisely, yeah.
to return, but have not been able to do so, and you have a visa, not have a visa, leave or exceptional assurance. So that's certainly what this is. It's primarily directed to people who have such a visa. You may request additional.
There's probably no answer to this, but I'll just put it. Why does it start with the statement, you are expected to take all reasonable steps to leave the UK where it's possible to do so? Or what? Who are these people who've been told to leave?
I'm not sure. I'm not. I think it's almost certainly in the world where there's a preconception about who this is speaking to.
Well, even that it doesn't really mean anything to me. Anyway, it doesn't matter. It is what it is.
It would have made more sense to switch that paragraph for the paragraph if you intend to leave the UK.
Anyway, there we are. Thank you.
It then describes what an exceptional case is, and that's the category that the claimant does not, the appellant does not fall into, or did not fall into. You then get to the next paragraph. It says, during the time in which your request for exceptional assurance is pending, you will continue on conditions as per your current or most recently expired visa. So it's envisaging, when we were referring previously to conditions of leave in the context of the letter, there's some support for the basis being looking back to the previously expired visa. We then get to the substance of what the exceptional assurance will be. It will act as a short-term protection against any adverse action or consequences after your leave has expired. This is the following paragraph in the policy. 87, bottom of 87. Thank you. So it's saying it's a short-term protection and it's against adverse action or consequences after your leave has expired. There's nothing about changing the effect of the immigration rules in respect of future applications, for example. It then goes on to say, if conditions allow you to work, study or rent accommodation, you may continue to do so during the period of your exceptional assurance. So that was the core of an exceptional assurance. It's also the core of what was promised to the appellant here. Exceptional assurance does not grant you leave. So it does not render you not in breach of immigration laws, for example. It means to protect those who are unable to leave the UK due to COVID-19 restrictions and not to facilitate travel other than to return home. So that's the thrust of what it's trying to do. It's not, again, saying anything about making a concession in respect of applications. It's not an amnesty. It's not saying it's a mechanism by which we will disregard previous periods of leave when you've been an overstayer. Sorry, previous periods of overstaying in future applications. That's not the thrust of the policy.
If we ignore a person like this, who has been an overstayer for a while, treat someone who's only become an overstayer during the currency of the exceptional assurance. The logic of what you're saying would appear to be that even such people cannot make an application for the future because there's no intention, but after the point at which they become overstayers and rely on the assurance.
Yes, save for the point that if you go look above, it said it's a short-term protection against adverse action or consequence. So the point is you couldn't have, during that short term, the adverse consequence of that period of, during that short-term period of the assurance being held against you.
So if you did have continuous periods of exceptional assurance or short-term assurance, let's say you successfully applied every 14 days, and there's no period that isn't covered by one of those assurances.
Yes.
Would you agree that you wouldn't be treated as an overstayer for the purposes of an application?
Yes.
Right.
Yes.
So I will put it another way. In relation to those to the days covered, you are not an overstayer.
Yes.
But standing back and looking at the whole period, if there was earlier, if the actual overstaying started earlier, as it did in this case,
yes,
the fact that you've got some protection for 14 days doesn't, in essence, protect the whole of it from being overstaying.
Yes, well, it's not. It's intent not to change the meaning of the immigration rules. It's specifically out with the immigration rules. What it is this special concession that sits in a layer on top.
So one way of looking at it might be the effect isn't to stop a current period of overstaying from being overstaying.
Yes.
It gives a short-term protection for the 14
Indeed.
days.
The position as at the date the assurance starts crystallises perhaps, and you're in that position throughout the period, but it's like it's effectively time is stopping running.
Well, I'm not even sure it's in your interest to say time has stopped running.
Well, for the purposes of periods of overstaying, time is ceasing to run. It can't be effectively it can't be held against you that you were in the country. Adverse consequence. You can't be held against you were in the country during that 14, specifically during that 14 days.
My point was more an adverse consequence seems to be things like enforcement action taken against you.
Yes.
It doesn't seem to extend to not being able to claim to be currently not in breach of immigration rules for the purpose of an application for leave to remain on a basis. Yet, certainly in the letter, you're being told you can do that, aren't you?
Well, the application point in the world of this makes a difference. In the world it's primarily addressed at, let's say somebody who their leave's about to expire.
Yeah. They
make the request. They get a proper exceptional assurance, 10 weeks.
Yeah.
Far longer than the 39E 2-week disregard.
Yeah.
And they make an application by the end of the exceptional assurance.
Yes.
A valid application. That will not be treated. They will not be treated as an overstayer, having done that.
But and that could tie in with the short-term assurance.
It could do.
If you your visa's about to expire, you apply for this. They say India no travel restrictions, so we'll give you 14 days.
Yes.
You've not started a period of overstaying at any point. You can make a genuine, valid application.
Yes.
Even during the 2 weeks, not just the 10 weeks.
It's unlikely to make a difference in most of those cases because, of course, you already have the 39E 2-week disregard. So if it makes a difference, it's marginal.
Okay. Is one way to look at it is the reference here is to adverse consequences. Whereas you could say the appellant is looking for something more.
Yes, yes. Well, I would say precisely that. And this applies to both the policy and the letter. What the appellant is, all of this, all of the language is about protecting you, not giving you something extra. And on any measure, the appellant is asking for something extra that is well outside of this 2-week period. He's asking for a long period of overstaying to be disregarded.
Well, he's trying it. The argument is that it cures an existing overstaying.
Yes, he's
I'm
saying
using the word existing rather than previous because
yes.
previous is
Indeed.
Problem.
So we then move down to the next section of the policy, which is also of relevance. We could turn over the page. The next paragraph, as it happens, is the point that your ladyship made about the possibility of repeated assurances being given. Potentially, if, for example, quarantine conditions haven't changed, or they've changed and changed back as they did throughout COVID. But there is then some guidance about if you intend to stay in the UK. It says you will need to apply for the relevant permission to stay. Where eligible, you'll be able to submit a permission to stay application form from within the UK. So it refers to being eligible. It doesn't refer to a person being made eligible by an assurance. Then says you can make an application for permission to stay in the UK if you hold permission in a route that would normally allow you to do so.
Okay, what does that mean?
Well, I think it's simply referring to the possibility of extending leave, an existing form of leave.
Quite a common situation is a student applying to stay for work.
Yes, so you might switch routes, I accept. Perhaps touch upon in the next paragraph, which is of particular importance.
Hang on, sorry. Would that switching to work wouldn't be an example within that paragraph? Would it be extending your student visa for extending study or something?
If you're a student, well, you could do either. Depending if you're planning to continue to study and you have sponsorship to do a master's or whatever following an undergraduate degree, you might apply, and it might be called the same route.
Phrase in a route that would normally allow you to do so. What is to do so? To make an application to stay in the UK. But if I have permission to stay as a student, that doesn't give me permission to apply for permission to stay as a student. I mean,
well, there are time-limited routes, working holiday, what used to be called working holiday visas, which are time-limited to 2 years, and you can't extend them. So it might refer to that.
Oh, well,
the other options.
Nothing ultimately turns on this from
No.
Mr. Mallett's point of view, and doesn't appear to from yours. So I shall personally not try and examine it further.
Yes. One can think of routes where that might be relevant. Not so important here. The next paragraph is important, though. You'll need to meet the requirements of the route you're applying for and pay the UK application fee. So it's not. It's very clear you need to meet the requirements of the route. It's not saying you can. There's some concession in terms of meeting the requirements of the immigration rules. Of course, the overstay requirement is one of them. It then moves on to touch upon the terms of your current permission will remain the same until your application is decided. Highlighting that this is primarily.
I mean, anything else? Those 3 paragraphs, 4 paragraphs, are just stating the general law anyway.
Yes.
The only bit that says something new, i.e. something relevant to the exceptional assurance policy, is the final paragraph.
Yes, you're able to apply for permission to stay to remain in the UK if it's issued with an exceptional assurance. You must submit your application before the expiry of your exceptional assurance. Yes.
But what does that mean, other than that it won't be held against you that you no longer have leave at the moment of your application?
Well, it will do. Well, in terms of.
I see. You say it does mean that.
It does mean
but
that.
Only if you had leave up to that point.
Yes. Yes, and that may be quite a significant advantage if you have a proper exceptional assurance of having 10 weeks to formulate your new application rather than only 2 weeks of overstay. You can imagine there would have been people for whom may have been weighing up whether or not they were going to go home or apply to stay. And this gives them some time to consider what they're going to do. So, the final element of the guidance to then refer to is the paragraph saying if you have overstayed your leave. And it's very specific, referring to if your visa or leave expired between 24th January 2020 and 31st of August 2020, there will be no further adverse immigration consequences if you did not make an application to regularise your stay.
What does that mean?
Well, that's a reference to the general concession during period 1 that we referred to before. That effectively there was a wider concession on all overstaying. There was not quite effectively an amnesty for that period. It was a general concession, which is now in the rules. Yes,
that's obvious. If, however, this document is circulating in 2022, so 2 years later. What about someone whose visa or leave expired after 31st August 2020? Why isn't that addressed?
Because there is no concession. And it's surprising that it didn't, if there was intended to be such a concession, that it didn't state it, even if that concession was subject to you making an exceptional assurance application. It says nothing. So you read all of that together.
So you're saying, well, this is the subheading under which you'd expect to find this
wider concession, yes.
provision.
And it's not there. So then you stand back and read all of this together, and in my submission it's very difficult to see how you could construe that as a policy. Forgetting what the letter says for a moment, construe that as a policy of saying, well, yeah, if you've already overstayed, you can now apply for an exceptional assurance and we will disregard the fact that you've previously overstayed prior to your exceptional assurance. It says nothing of the sort. And indeed, there are several points at which it suggests otherwise, including where it says you must comply with the immigration rules for your further application. And the absence point, which I I've just highlighted now. So if we now hang that together with the letter, the letter is written against the background of an exceptional assurance application. It's difficult to see how, if someone is reading that letter alongside the policy, in my submission, it's a leap to say I've received an unambiguous promise of a waiver of this or disregard of this overstaying period on the basis of the policy. Because the policy doesn't make any such promise. And of course, that also answers the point that Mr. Malik says, oh, my client's entitled to this concession on the basis of the policy. Even if he is entitled to rely upon the policy as being the basis for his client's rights, in terms of how his application is dealt with, it doesn't support what he says is the outcome the Secretary of State should have reached.
That's because the short-term assurance isn't covered by the policy at all. Is that the reason why?
No, it's twofold. One, it's because, let's say the short-term assurance is covered by the policy. Let's say it was, and Mr. Malik says they're all the same thing. I say no, they're not, because the letter says something else. But let's say they are all the same thing.
Yes.
It doesn't matter, because the policy doesn't entitle him to what he says it does. It doesn't suggest if you make an application during the period of the exceptional assurance, you will not be treated as an overstayer for any purpose. As we've seen, it doesn't even go so far as to give the assurance in the wording we saw at paragraph 13 of the letter. It doesn't use those words during the period. I should know them off by heart, shouldn't I don't? During this time, you'll not be regarded as an overstayer or suffer detriment in any future applications. That's not what the policy says. So if that's, and that is in my submission, that's the basis for where it's Mr. Malik says he gets his legitimate expectation. He interprets the letter in accordance with the policy. In my submission, if that's correct, then the Secretary of State again must win. Unless I can assist you further, I have no further submissions.
Yeah, thank you, sir. Yes, Mr. Malik.
So my learned friend, I think in answering a question by my Lord the Vice President, suggested that the heading of the assurance letter was misleading. The heading that stated that it was confirmation of exceptional assurance. That suggestion or submission is not supported by evidence. In fact, it is inconsistent with the evidence of George Shirley. My learned friend has not in my respectful submission, answered the point that I made based on his witness statement.
Well, he did more or less at the end. He said ultimately it doesn't matter, even if you're right that you can classify this kind of short-term assurance as an assurance under the policy. It's still, if you look at the policy and the letter in the light of the policy, doesn't give you what you need. So
Yes.
Go on.
Yes. Yes. But it is nevertheless an exceptional assurance as referred to in the policy. I think the learned friend accepted that there was no material difference between an exceptional assurance or the short-term assurance, as he would put. But by there being no material difference, I meant that both species gave same sort of entitlements to the person to whom they were issued. So when a person applies for exceptional assurance, the Secretary of State has three options. The Secretary of State can grant the extended assurance. The Secretary of State can grant limited assurance, or the Secretary of State can reject the application for assurance. If the Secretary of State grants an assurance, whether it is extended or limited, it has the same effect. If a person has overstayed already prior to the pandemic, then the Secretary of State can refuse the application for exceptional assurance on that basis. The policy is silent about it, but I certainly have seen many rejections refusing applications for assurances on the basis that a person has already been an overstayer. So my submissions, if accepted, will only affect those who became overstayers during the pandemic. So it won't have an effect of assisting everyone who had overstayed prior to 24th of January 2020. Miller and Trent says that the assurance letter does not say as to how the Secretary of State will deal with any future application. I accept that, of course, but that in my submission does not really answer the point. Miller and Trent says on the policy that he has just shown you, that it only applies to those who apply for assurance before the expiry of their leave. I think this is ultimately comes down to this as to whether the policy applies to overstayers generally, those who overstayed during the pandemic, or it only applies to those who applied for assurance before the expiry of leave. Now, if the Secretary of State had intended the policy to apply only to those who apply for exceptional assurance before the expiry of the leave, she could have said so. She could have said so in the policy. She could have said so. She could have said that, well, this only applies to those who make in-time applications for assurances. The fact that she did not say so, in my respectful submission, means that the intention was that it would also apply to overstayers. Now, in addition to that, there are several pointers in the policy that tend to suggest that it also applies to overstayers. I have taken you to those pointers in my opening submissions. Page 86, second last paragraph, there's a distinction between expiry of leave and exceptional assurance. Page 87, there is reference to expiry of most recent visa, and then, of course, there are express references to overstaying. The submission that Millennium makes is also inconsistent in my submission with the opening words of the policy. Well, a person who has leave to remain, is not required to leave. Why would the policy then say at the outset that you should take reasonable steps to leave the UK as soon as possible, or apply to regularize your stay in the UK, unless the intention was to address it to those with expired leaves? In my respective submission, in conclusion, on the straightforward analysis, the court should ask itself two questions. First, what was the appellant's status on 29th of November 2022? The answer is that he was in the UK on that date, pursuant to a permitted stay. The Secretary of State, permitted stay is the phrase that the Secretary of State has used. And on that date, he was not considered to be an overstayer, pursuant to the letter. That's the answer to the first question. The second question that, in my submission, the court should ask itself is, does paragraph SW 2.2 of the immigration rules allows the Secretary of State to refuse an application made by a person who, on the date of the application, was not considered to be an overstayer? The answer in my respectful submission is no, because the rule concerns present breaches of immigration law, and that now seems to be a common ground. Lord, these are the points that I wanted to make in reply. I'm very grateful.
Thank you both very much. We will be reserving our decision. Judgments will be circulated in draft in due course for the purposes identified in the Counsel General for Wales case, and only for those purposes which will of course affect who they should be circulated to. If they're circulated any more widely than is necessary for those purposes, there may be that may constitute a contempt of court. I think the only loose end, which has already been attended to, is giving us the correct version of the policy, and we'll find that in our inboxes when we get back.
Yes, just to confirm, the report in the authorities bundle is the most authoritative report.
I thought it would be. I know you get in trouble about those things, but I thought it was just worth checking.
Yeah.
Thank you.
Okay.